The courtroom battle between 23XI Racing, Row Motorsports, and NASCAR has unfolded into a clash of competing narratives, each side examining the same financial records yet arriving at vastly different conclusions. That contrast became the heart of another revealing day in court, as the jury continued to explore whether NASCAR used its monopsony power to disadvantage the very teams that make up the Cup Series. NASCAR Chief Financial Officer Greg Motto spent nearly 2 hours on the stand, fielding questions about how the company distributes money to the France Family Trust and how those financial decisions ripple across the entire sport. Because NASCAR is structured as a private S-corporation, its income and losses are passed directly to the shareholders, every one of them a member of the France Kennedy family. The team's attorney, Jeffrey Kessler, argued that NASCAR could afford far more generous charter payments, perhaps even hundreds of millions more each year. Motto disagreed, insisting such payouts would bankrupt the sanctioning body. Again and again, both sides dug into the same documents but pulled out different realities. Kessler also continued pressing a central theme of the trial, that NASCAR's financial projections assume business continues exactly as it always has, with consistent salaries and operations, even though the pandemic proved that compensation cuts were absolutely possible when necessary. He argued that, in a fair system, increased team payments would be matched by financial adjustments throughout NASCAR's structure. Later, the focus shifted to John Probst, NASCAR's Senior Vice President of Innovation and Racing Development. He offered insight into the creation of the next-gen car and the philosophy behind single-source parts. According to Probst, the idea was to limit excessive spending and increase parity, making the sport more competitive and sustainable. But Kessler reminded the court that the lawsuit isn't about the car itself, it's about the non-compete restrictions in the charter agreement. Tension grew as internal emails surfaced, including one where NASCAR leaders debated whether modifying the older Gen 6 car would risk inspiring a copycat series. Probst insisted NASCAR doesn't fear competition, though Kessler pointed to exclusivity clauses implemented shortly after rival series like SRX emerged. By day's end, the courtroom had dissected millions of dollars in expenses, questioned motives behind internal decisions, and dug into long-buried conversations. And while NASCAR maintains its decisions protect the sport's stability, the teams argue they've been financially suppressed by a system designed to keep power tightly guarded. As the trial continues, one thing is clear: the battle for the future of stock car racing won't be decided on the track, but inside this courtroom.